The legal battle between NASCAR and the racing teams, 2311 Racing and Front Row Motorsports, has become one of the most talked about controversies in motorsports today. At the center of this dispute lies NASCAR's charter system, a business model designed to provide stability and guaranteed participation for teams in the Cup Series. However, 2311 Racing, co-owned by basketball legend Michael Jordan and NASCAR driver Denny Hamlin, along with Front Row Motorsports, argue that this system is anti-competitive and monopolistic, creating barriers that unfairly limit opportunities for newer or smaller teams. This conflict escalated after NASCAR introduced a new charter agreement for the 2025 season. Both 2311 Racing and Front Row Motorsports declined to sign this agreement, which led NASCAR to revoke their charter statuses. Losing a charter is a major blow. It removes guaranteed entries into races, reduces revenue-sharing opportunities, and puts teams at a significant disadvantage in the competitive landscape. In response, the two teams filed a high-profile antitrust lawsuit against NASCAR and its CEO Jim France, accusing the sanctioning body of abusing its dominant position in stock car racing. They claim NASCAR is exploiting this dominance to marginalize certain teams and maintain control over the sport's business practices in a way that stifles competition. NASCAR fired back with a lengthy 34-page response opposing the team's motion for a preliminary injunction that would have forced NASCAR to reinstate their charter status for the 2025 season. The sanctioning body argued that by refusing to sign the new charter agreement, 2311 Racing and Front Row Motorsports effectively forfeited their charters. NASCAR also pointed out that multiple other parties had expressed interest in acquiring those charters, reinforcing the argument that NASCAR is under no legal obligation to maintain business relationships with teams that reject the terms it sets. One of NASCAR's strongest arguments focuses on the significant increases in financial payouts to chartered teams. In the latest agreement announced in September 2024, NASCAR increased payouts by over 65%. While exact numbers were not disclosed, NASCAR emphasized that its revenue-sharing system is more generous than those in other major racing leagues, such as Formula One, where teams collectively receive roughly 50% of commercial profits. This contradicts the team's claims that NASCAR's system is unfair or exploitative. The legal filings also go after the motivations behind the lawsuit itself. NASCAR accused 2311 Racing and Front Row Motorsports of conspiring together as an illegal cartel, with Michael Jordan's longtime business partner, Curtis Polk, named as a defendant. NASCAR alleges that Polk played a central role in coordinating collective conduct aimed at pressuring NASCAR into accepting the team's terms, which NASCAR says violates antitrust laws. The stakes could not be higher. Should the team succeed, the outcome might dramatically reshape the sport's charter system, changing how NASCAR governs team participation, revenue sharing, and competitive balance. NASCAR has long maintained that the charter system is essential to provide stability and financial security for teams, allowing them to compete sustainably in a sport with significant operating costs. To defend its position, NASCAR has enlisted top sports law attorney Chris Yates, known for representing high-profile clients such as the UFC and U.S. Soccer Federation. The choice of counsel highlights the seriousness with which NASCAR is addressing this lawsuit and its commitment to protecting its business model. Despite the legal battle, 2311 Racing and Front Row Motorsports are currently operating without charters. This forces them to qualify for races on speed and compete without guaranteed revenue-sharing benefits, making their path more difficult. The uncertainty over their future participation remains, especially after the U.S. Court of Appeals for the Fourth Circuit recently overturned a previous injunction that had allowed them to compete as chartered teams for the 2025 season. This ruling effectively removed their guaranteed race entries and financial benefits, heightening the pressure as the trial date approaches on December 1st. At the heart of this dispute is a fundamental question: is NASCAR's charter system a necessary framework for the sport's growth and stability, or does it act as a monopolistic barrier that limits fair competition and access for smaller teams? 2311 Racing and Front Row Motorsports argue that the charter system disproportionately benefits NASCAR and an exclusive group of teams, creating a closed environment that hinders the growth of new or less established teams. They assert that NASCAR's control over charters and revenue allocation suppresses competition and favors those who already hold power within the sport. NASCAR rejects these allegations. The sanctioning body asserts that the charter system creates a level playing field by guaranteeing teams financial stability, which is crucial for their survival and success given the high costs of racing. NASCAR points out that charters also provide opportunities for new teams to enter the series through the sale of existing charters, promoting expansion rather than exclusion. The lawsuit has drawn significant media attention, in part due to the high-profile nature of 23XI Racing's ownership group. Michael Jordan's involvement brings a global spotlight to what might otherwise be seen as an internal business dispute within NASCAR. The case also highlights shifting power dynamics in the sport, with new team owners pushing back against established practices. NASCAR's counterclaims further emphasize the tension, accusing 23XI Racing and Front Row Motorsports of anti-competitive conduct in attempts to undermine the integrity of the sport. These allegations deepen the complexity of the legal fight and add a layer of personal conflict, especially with Curtis Polk named directly in NASCAR's filings. Financially, the stakes for the teams are immense. Without charters, they lose guaranteed entry into races and the stable revenue streams that come with it. This not only threatens their competitive viability, but also their ability to attract sponsorships, which are vital for funding operations. Competing without the safety net of a charter means qualifying on speed alone and facing a much riskier financial landscape. The court's decisions in this case could set precedents for how NASCAR and potentially other motorsports leagues manage their team structures and revenue-sharing models going forward. A ruling in favor of the teams might lead to fundamental changes in NASCAR's governance, opening the door for greater competition and possibly restructuring how charters are issued and managed. Conversely, a ruling favoring NASCAR would reinforce the current system's legitimacy, allowing the sanctioning body to maintain tight control over team participation and financial arrangements. This could preserve the status quo, with benefits for established teams but ongoing challenges for those seeking to enter or expand within the sport. The trial scheduled for December 1st promises to be a landmark moment in the history of NASCAR. Both sides are gearing up for a rigorous legal battle, with the future of the sport's competitive and business landscape hanging in the balance. For now, fans and industry insiders alike watch closely, aware that the outcome could reverberate through NASCAR for years to come. The 23XI Racing lawsuit has exposed deep divisions in how the sport is managed and raises important questions about fairness, competition, and the balance of power in America's premier stock car racing series. As this story continues to unfold, one thing remains clear: NASCAR and its teams are at a crossroads, facing decisions that will shape the future of racing and its place in the broader sports world. Whether the charter system survives this legal challenge or evolves into something new, the fight between NASCAR and 23XI Racing marks a pivotal chapter in motorsports history.